Leslie, Ryan Preston Revis, Stephanie Ann Allen Long, and Megan Laurel Miller.
All right, if you will raise your right hands, please turn and face the clerk. She will administer the oath to you this morning.
You do solemnly swear that you will conduct yourself as an attorney or counselor of this court, truly and honestly, justly and uprightly, and according to law, and that you will support the Constitution of the state of Georgia and the Constitution of the United States. So help you God.
All right, it is the custom of our court that one of our judges will impart words of wisdom to you after having been sworn in, and that task today is Justice Robert Bantams.
Thank you, Chief. On behalf of Chief Justice Sears, Presiding Justice Hunstein, Justices Carley, Thompson, Hines, Melton, and myself, and on behalf of our clerk and court staff, it's a rare pleasure and a real privilege to welcome you to practice before the Supreme Court of Georgia. And reaching this point, it's taken some hard work, some dedication, determination, and sacrifice. But in order to reach this point, you didn't reach it by yourself. Through those long and difficult days in law school, you had the support of your family, your friends, and your well-wishers, and I'm sure they all take a great amount of pride in the accomplishments that you've had over a period of time. Just a few words, not necessarily of wisdom, but I'm celebrating 37 and counting years at the bar, and there are 3 of us on the court who are celebrating our birthday today. Justice Carley, whose birthday was yesterday, Justice Melton, whose birthday is today, Justice Hines, whose birthday was earlier in the month, and of course this is my birthday too. And it gives me a chance to reflect. Your profession is the legal profession, and in order to impress upon you the real critical role that you play, let me share with you a poem by an unknown poet. It's called The House by the Side of the Road. It says, there are hermit souls that live withdrawn in the peace of their self-content. And their souls like stars that dwell apart in a fellowless firmament. But then there are pioneer souls who blaze new trails where highways never ran. So let me live in a house by the side of the road and be a friend to man. I can see from my house by the side of the road, by the side of the highway of life, those who press with the ardor of hope, those who wither from the strife. I share their joys. I feel their pain. They're all part of a master plan. So let me live in a house by the side of the road, be a friend to man. You have a house. You've chosen the courthouse, and the courthouse has a role. It's a place where we heal our community. It's a place where we solve problems. It's a place where we bring people together. And it is a place where the American dream is still alive and well. This is one of the few countries where the citizens are actively engaged in whatever house they're in pursuing the American dream. I hope that you will use your skills and your tools as lawyers to help your fellow citizens pursue and achieve the American dream. Congratulations, good luck, and best wishes. If you will now follow the clerk, sign the roll, pay a minuscule fee, you will be duly authorized to practice healing your community in the great state of Georgia.
Thank you. Good luck. Thank you. As they take their leave, I'm going to go ahead and call the first 2 cases set for oral argument. Woodham versus City of Atlanta et al., case numbers S07A1309 and S07A1566. And as the lawyers are making their way up, let me just outline the timing. Of course, each side has 20 minutes to present their side of the case. At the expiration of 15 minutes, an amber light will come on, and that will indicate that you have 5 minutes left. And at the expiration of 20 minutes, a red light will come on, and you will have to stop.
John Floyd Woodham for the appellants, Charles Johnston, and Matthew James Calvert for the appellants.
Thank you. You may proceed.
Good morning. May it please the court, my name is John Woodham. I am the pro se appellant in these two companion cases that concern the City of Atlanta BeltLine project. As the court is aware, I've raised a number of procedural and substantive issues. In light of the limited time this morning, I'm going to focus primarily on the constitutional issue that vested jurisdiction in this court, and that issue is the unconstitutional use of school tax funds to fund City of Atlanta infrastructure improvements under the City of Atlanta BeltLine project. And there are three critical components that lay the foundation for this discussion and argument. The first is the plain wording of the Constitution itself. Article 8, Section 6, Paragraph 1A of the Constitution, which I refer to as the School Tax Levy Clause, allows the levy and collection of school tax funds solely for the support and maintenance of public education. Likewise, Article 8, Section 6, Paragraph 1B of the Constitution, referred to as Educational Purpose Clause, states, school tax funds shall be expended only for the support and maintenance of public schools, public vocational technical schools, public education, and activity necessary or incidental thereto, including school lunch programs. The second element that lays the foundation for this argument is this court's holding in DeKalb County School District v. DeKalb County, 263 Georgia 879. A unanimous decision of this court in 1994, wherein the court held that school tax funds could not be used to fund county road improvements. What the DeKalb County case tells us is that school districts operate in different spheres from counties and cities, with the school district functioning principally to enhance the education of our youth, and cities and counties functioning to provide a broad range of other services to the citizens of cities and counties. The holding in DeKalb County tells us that using school tax funds to fund city and county infrastructure improvements strays too far from the education of our youth and encroaches into areas generally reserved to cities and counties.
Is the reason for the dichotomy, I know the school board sets the millage, the tax for their budget.
That's correct. And
the county or city sets the millage or tax for their budget. Is that, and there's a cap on how much school tax can be levied in one tax year.
Well, there's a 20% cap under the Constitution that actually doesn't relate to independent school systems.
Is there a fear that that somehow the county or city and the school board are getting cahoots, and the county may be able to tax enough under their budget, and so the school board taxes to make up the shortfall?
I think in the DeKalb County case, the court simply determined that these funds are precious and they are levied for this particular purpose under the Constitution, and they're put in a special box, and you can't touch them for any other purpose.
It's not a lockbox like we heard a couple years ago.
I don't know that it's a lockbox, but they're considered precious special funds that simply can't be used for another purpose. And the DeKalb County case determined that taking funds from that box, if you will, and using them to fund general infrastructure that are areas generally reserved to cities and counties is not an educational use. The third foundation for this argument is this court's decision in Wright v. Absalom, 224 Georgia 6, which sets forth some very basic common law constitutional principles in this state, where a constitutional provision expressly provides that taxes levied and collected may be used only for particular purposes. Such funds cannot be utilized for or diverted to any other purpose. The object of an expenditure may be a very worthy cause, and highly beneficial to the general public, but this will not suffice where the constitutional authorization is lacking. And with these three components in mind, this is really a very straightforward case. The undisputed evidence in this case shows that the BeltLine project is simply a massive City of Atlanta public infrastructure project. It involves transit construction, greenway and park acquisition, road improvements, utility installation, etc. This case is simply the DeKalb County case, but on a much, much larger scale. And as in DeKalb County, these City of Atlanta infrastructure expenditures are matters generally reserved to cities and counties, and they stray too far from the education.
Is your position that if we rule against you, we would have to overrule or modify DeKalb County? Is it so controlling?
And I believe so.
Your argument, Mr. Woodham, is you look to the little language and you look to DeKalb County, and that's what your argument is.
And to write the Absalom.
Well, right, but you say
correct. And in this case, because the City of Atlanta infrastructure improvements are matters generally reserved to cities and counties, and they stray too far from the education of the children, it makes the BeltLine project unconstitutional. And the evidence shows that the school tax dollars will account for approximately $918 million of the total $1.7 billion in tax allocation in this case. The city has agreed to give back to the school district $160 million in direct payments under 364438G of the Redevelopment Powers Law, but what this means is $758 million of school tax funds will be diverted to pay for City of Atlanta infrastructure improvements, which under the principles laid down in DeKalb County are clearly non-educational. Again, these city infrastructure improvements contemplated in the BeltLine may be very worthy and highly beneficial to the citizens of Atlanta. But again, as stated in Write the Absalom, that will not suffice when the constitutional authorization is lacking. And I think it's critical for the court to note that on page 21 of the trial court's order of 12306, based on the evidence presented, the trial court stated, quote, "It seems clear that many of the expenditures contemplated for the BeltLine redevelopment plan could not ordinarily be considered ones which would fall within the Educational Purpose Clause's definition of expenditures for the support and maintenance of public schools," close quote. So that's a powerful statement by the trial court that I would argue is actually a finding and a holding that the BeltLine project is unconstitutional based on the principles laid out in DeKalb County. That finding alone should have frankly ended the case and have caused the court to rule in favor of the intervenors. But instead of so ruling, the court focused on 3644.9 of the Redevelopment Powers Law, which is the provision that allows a school district to contribute financially to a tax allocation district. And the court determined there was a conflict between the Educational Purpose Clause and the Redevelopment Powers Law. But instead of attempting to resolve this apparent conflict by way of looking within the Redevelopment Powers Law itself, to see if the Redevelopment Powers Law is susceptible to a construction consistent with the Educational Purpose Clause, which courts are required to do first under Wickham v. State 273, Georgia 563, among others, the court simply elevated the entire Redevelopment Powers Law itself to constitutional footing. In essence, including the Redevelopment Powers Law, statutory enactment is part of the Constitution. And I'll address that more fully in just a minute. But as I've contended in my brief, I believe the Redevelopment Powers Law is easily susceptible to a construction consistent with the mandate of it under the Educational Purpose Clause. I believe that the Redevelopment Powers Law does allow a school system to contribute financially to a tax allocation district as long as those funds are used for an educational purpose, such as to build a new school. And if there's any excess money that goes into the district, then it flows back to the school system. However, in a case like this, when the overwhelming majority of the school tax contribution is earmarked for purposes which are clearly non-educational based on the principles set forth in DeKalb County, we end up with an unconstitutional diversion of school tax funds away from the support and maintenance of education. If the Redevelopment Powers Law is not susceptible to a construction consistent with the Educational Purpose Clause, then it was the trial court's duty and mandate under Article 1, Section 2, Paragraph 5 of the Constitution to declare the Redevelopment Powers Law, and specifically 3644.9, unconstitutional in violation of the School Tax Levy Clause and the Educational Purpose Clause. As this court stated in Glover v. Donaldson, 243 Georgia 479, quote, "It is axiomatic that the legislature's power to pass laws is limited by the Constitution itself, and a law authorized generally by one provision of the Constitution may not contravene another provision of the Constitution." Now, that is the law in this state, and that is precisely the situation in the case now before this court. The Redevelopment Powers Law is merely a statutory enabling act, generally authorized by the permissive authority of Article 9, Section 2, Paragraph 7b of the state Constitution. Which is referred to in this litigation as the Community Redevelopment Amendment. Therefore, based on the foregoing principles, the Redevelopment Powers Law may not contravene the absolute mandate restricting the use of school tax funds contained in the Educational Purpose Clause. Now, just as an aside, reference to the Community Redevelopment Amendment as an amendment is somewhat of a misnomer because it was actually part of the 1983 Constitution along with the Educational Purpose Clause. They were both part of the original Constitution. When we look at the language, the actual language of the Community Redevelopment Amendment, we simply see a permissive grant of legislative authority allowing the General Assembly to grant to counties and municipalities for redevelopment purposes and in connection with redevelopment programs, as such purposes and programs are defined by law, the power to issue tax allocation bonds. We also see that even after a General Enabling Act is adopted by the General Assembly, a local law is still necessary and a local public referendum is still necessary before it becomes effective in any particular jurisdiction. And when we look at the language of the provision, we also see there is no language whatsoever concerning the use of school tax funds or otherwise addressing itself to the power of school districts and school systems in the state of Georgia to do anything. The Community Redevelopment Amendment addresses itself exclusively to counties and municipalities. It deals with an entirely different subject matter than the Educational Purpose Clause, so there is clearly no conflict between the two provisions. One is a self-operative mandate restricting the use of school tax funds, and the other is simply a permissive grant of legislative authority dealing with cities and counties. And I think it's this lack of an actual conflict between the two provisions that creates a problem for the appellees and apparently for the trial court, so they proceed to manufacture a conflict by simply elevating the Redevelopment Powers Law, a statutory enactment, to constitutional footing, particularly 3644-9, so that if 3644-9 suddenly becomes part of the Constitution, they then argue that it implicitly amends the Educational Purpose Clause or somehow must be harmonized with it. But in doing so, the trial court, while actually acknowledging the principles set forth in Glover, i.e. a law authorized generally by one provision may not contravene another provision, the court promptly proceeded to completely ignore those principles. On page 24 of the court's order of 12306, the trial court stated, Mr. Woodham argues that the Redevelopment Powers Law is simply a statute rather than a part of our state constitution, and when a statute conflicts with a constitutional provision, the statute must fail. This is correct as a general rule. In this case, however, it is clear that the statute in question was enacted in order to implement a constitutional amendment, the Community Development Amendment. As a statute in implementation of a constitutional amendment, it stands on a footing, close quote. The trial court cited this court's decision in Campbell the Department of Corrections 243 Georgia 479 for this proposition. And this statement, by this statement, the trial court has created new law in this state by holding that a simple enabling act gains constitutional footing. This is plainly a misstatement of Georgia law. The Georgia Code is replete with enabling acts which are mere implementations of permissive constitutional authority. Enabling acts do not become part of the Constitution. Enabling acts based on permissive constitutional authority are precisely the type of general laws covered by the principles set forth in Glover, i.e., a law generally authorized by one provision of the Constitution may not contravene another. And it appears that, frankly, neither the trial court nor the appellees in this case have actually examined the respective holdings in Glover and Campbell to determine what the holding in Campbell actually stands for. In Glover, this court, in applying the foregoing principles, it held that statutory venue limitation set forth in the MARTA Act was unconstitutional because it was not conditioned upon MARTA's waiver of sovereign immunity. Applying the Glover analysis in Campbell, the court in Campbell held, quote, while it is axiomatic that a statute standing alone may not contravene a constitutional provision, OCGA section 50-2128 is the implementation of a constitutional amendment not only authorizing the adoption of the GTCA, but also the limitation on the waiver of sovereign immunity contained therein.
One normally thinks about changing the Constitution by constitutional amendment. These authorizations in the Constitution for statutes, those statutes could be amended by the General Assembly without going back through the vote of the people as to a constitutional amendment. Is that correct?
Well, I would contend if the question is if the Redevelopment Powers Law was part of the Constitution, then you're in a conundrum, because then the General Assembly can't later amend the Redevelopment Powers Law. If it's part of the Constitution, then it needs to go through the constitutional amendment process, and that's an issue I've raised in my brief, that the subsequent amendments to the Redevelopment Powers Law, which didn't follow the constitutional amendment process, are all null and void. And that would include House Bill 1361, which the trial court and the appellees rely on. So you get yourself into a problem when you want to call the original statute part of the Constitution. To amend it, you have to follow the constitutional amendment process. Back to exactly what the court said in Campbell, it was the phrase, but also the limitation on the waiver of sovereign immunity contained therein, which is the actual holding that distinguishes Glover and Campbell. And this court later confirmed this in Dean v. Tapsom, 272 Georgia 831, where it said, simply stated in Campbell, we held that OCGA section 50-2128 was constitutional because the state's waiver of sovereign immunity was expressly conditioned on the venue limitation codified in it, close quote. So instead of focusing on the substance of the actual holding in Campbell, the trial court seized upon the simple phrase, OCGA section 50-2128 is the implementation of this constitutional amendment, close quote. That phrase was simple dicta leading up to the actual holding, which the trial court then took completely out of context. This was not the holding itself. The trial court thus misinterpreted and misapplied Campbell to stand for the blanket assertion that an enabling act adopting an implementation of a constitutional amendment has constitutional footing. Campbell does not stand for this proposition, and Campbell did not supplant the well-settled principles set forth in Glover. And if the blanket assertion put forth by the trial court in Appellees is correct, then MARTA should have prevailed in the Glover case, because the MARTA Act is the statutory implementation of the constitutional amendment authorizing the creation of MARTA. And it seems that MARTA even attempted this argument in Glover, but was turned away by this court as revealed in 6 on page 43 of Glover. There is clearly a distinction in this state between constitutional law on the one hand and statutory law on the other. And if the framers of the 1983 Constitution had intended any portion of the Redevelopment Powers Law to constitute constitutional law as opposed to a mere statutory enactment, they could have so provided. However, they did not do so. And I would cite the court to Services Employees International Union v. Purdue 280 Georgia 379 on that basis. In summary, this case is controlled by Wright v. Absalom in DeKalb County. Based on the principles set forth in Wright v. Absalom in DeKalb County, the BeltLine project very clearly violates the Educational Purpose Clause. The school system has neither the legislative discretion nor the constitutional authority to waste away $758 million in school tax funds on non-educational purposes. And there is nothing about the Community Development Amendment or its enabling act, the Redevelopment Powers Law, which operates to cure this clear violation of the Constitution. So if the policymakers of this state wish for school tax funds levied under the School Tax Levy Clause to then be diverted and used for non-educational purposes, they should put forward the necessary constitutional amendment to the Educational Purpose Clause and then let the people decide. Thank you for your attention. I will reserve the balance of my time for rebuttal.
Thank you very much.
Matt Calvert for the City of Atlanta. May it please the Court. The elected representatives of 3 local legislative bodies in a cooperative effort to promote redevelopment and to improve the quality of life in Atlanta voluntarily pledged their ad valorem tax increments in full compliance with the Redevelopment Powers Law to facilitate a widely supported long-range plan known as the BeltLine. This appeal of the trial court's well-reasoned orders validating the BeltLine bonds and upholding the associated governmental actions raises more than 15 enumerations of error, but they essentially fall into 3 categories. Issue 1 is the Educational Purpose Clause, and the question there is, did the trial court properly reject the appellant's contention, his constitutional challenge to the Redevelopment Powers Law, and to its application in this case?
Let me ask you this. What do you say regarding the DeKalb County case? Do you believe it would have to be overruled? Do you think it's distinguished? And what is the literal reading of the Constitution? If the literal wording is clear, do you go past that, the constitutional provision?
Your Honor, we believe the DeKalb County case is easily distinguishable.
You think the DeKalb County case is good law then?
That's right. We do not seek to distinguish it. It need not be overruled. The literal language of the constitutional provision, which Mr. Woodham has set up on the screen, is that school tax funds shall be expended only for the support and maintenance of public schools and activities necessary or incidental thereto.
All right. Would there be any activities not incidental to a public school, you think, in an ambit of a public works program?
Your Honor,
any public works program probably benefits public schools incidentally, wouldn't it?
But Your Honor, that's not the basis of the argument. And counsel for APS will elaborate on this in much more detail in explaining APS rationale for supporting this. Necessary or incidental means, is there a benefit from the pledge of the increment that's necessary or incidental to public schools? And our position is there are significant benefits necessary or incidental, which Mr. Johnson will elaborate upon. And the court also pointed these out in terms of the judge's rationale for...
That renders the constitutional provision meaningless, doesn't it?
No, it does not, Your Honor. Necessary or incidental, based on the trial judge's rationale, was, and this was her way of harmonizing the constitutional provision in the statute. The Redevelopment Powers Law, as an implementation of the Community Redevelopment Amendment, provided a mechanism by which the school district could pledge some of its increment in support of a long-range increase in its ad valorem tax base, essentially constituting an investment in the future, an increase in its tax base. It's important, Your Honor, in understanding this principle, to go back and look at what preceded the exercise of the redevelopment powers in this particular case. Initially, the Community Redevelopment Amendment that was supported by a statewide referendum had to be adopted. Second, the legislature had to implement that amendment through the Redevelopment Powers Law. Third, a local law of the General Assembly had to authorize the City of Atlanta to exercise redevelopment powers. And fourth, the voters of this city of Atlanta in a special election authorized and approved of the City of Atlanta's exercise of redevelopment powers, including the pledge of educational ad valorem tax increments. Those are the approvals that preceded this. And next, of course, the 3 legislative jurisdictions had to agree to the joint pledge.
Could you elaborate? You said this could be distinguished from DeKalb County. How? Just
several ways, Your Honor. First and foremost, in the DeKalb County case, the school board opposed the use of its school funds for the construction of the road. There was no constitutional enabling provision that allowed school tax funds to be used for a road under those circumstances. There was no legislative implementation of a constitutional provision. There was an objection by the school system. Here there's a statute, and this method of pledging educational ad valorem taxes in support of a redevelopment project can only happen with the consent of the school system. So that alone is a significant basis for distinguishing. And the other significant basis for distinguishing is the necessary or incidental benefit to the support and maintenance of public education. And our position here is it's the benefits, the many benefits that the school system negotiated in terms of financial payments and other specific benefits, payments in lieu of taxes and so forth, which APS's counsel will elaborate upon. But the point that Mr. Woodham ignores is that in this case, the City of Atlanta made a legislative determination that the redevelopment area, on the whole, could not reasonably be expected to be developed in the absence of this plan. The appellant contested that legislative finding in the trial court. His objection was overruled. He has not appealed that. For purposes of this case, it is undisputed that but for the BeltLine plan, but for the pledge of the educational ad valorem tax increment, this increase in the tax base, this increase in projected future educational ad valorem taxes would never occur. So the school system is not giving up taxes now. It is facilitating the improvement of the redevelopment area and the increase in the tax base. And that's a significant difference that we think he ignores in trying to distinguish the cases.
And that's your constitutional door. That's the door you're going through.
Well, that goes to the question of necessary or incidental. But
that's the door you're using, though, right?
That's one of the bases, Your Honor, and it's the bases that the trial judge relied upon in determining that this was a constitutionally enabled legislative action approved at the state and local voter level that allowed a long-term incidental benefit to the school system's tax base. And in the meantime, there are many other tangible financial benefits the school system will enjoy from this, which we submit independently on itself would justify affirming the trial court's decision.
But basically, I mean, the vision is that as new development increases, city's tax base increases, and that is beneficial to the school system.
It certainly is. It's beneficial to any local taxing authority. The BeltLine is projected to increase the tax base in that area alone by $20 billion. And we submit, as the trial court concluded, this is an appropriate long-term investment. This cannot happen without the consent of the school board. The school system is not forced to enter into this sort of agreement. And we think it's a legislative determination, as Mr. Johnson will elaborate upon on more detail. I think it's important for the court to make note that in Mr. Woodham's supplemental brief, which I noted was 60 pages but split into two parts, he attempts to refer this court to cases in two other states. The Kentucky Supreme Court case that struck down a state law allowing tax increment financing, and the Washington State case. Those cases, he says, reject the reasoning of the trial court in this case, and we submit those cases are easily distinguishable. In the Kentucky case, there was no constitutional enabling amendment that facilitated the enactment of redevelopment powers and the use of tax increment financing, including the pledge of an ad valorem tax of a school system. In the Washington State case, there was not a constitutional enabling amendment. In fact, in Washington, the state voters had twice rejected referenda approving a constitutional amendment. In neither of those cases was the school system's participation voluntary. In neither of those cases was there any evidence that the school system negotiated or was to receive any benefit from the pledge of their increment. A case that is more appropriate for the court to look to, if it chooses to look outside of its own law, is the Texas case that Mr. Woodham has not cited. It's El Paso against El Paso Community College, 729 Southwest 2nd, 296, a 1986 case. In that case, the Texas Supreme Court upheld tax increment financing, including the pledge of an educational taxing jurisdiction, because of a constitutional enabling amendment.
Is that cited in your brief?
It is not cited in our brief.
One more time, Bill, the citation.
It is El Paso against El Paso Community College, 729 Southwest 2nd, 296, 1986.
You want a brief? Okay. If you want to send it in a letter brief, we can distribute it.
We will do that. We thought it appropriate to cite it because of the supplemental brief filed last week in the resort to cases outside of the state. But the important thing about the Texas case was, in that case, there was no requirement of voluntary school participation. There was no requirement of any tangible, identified benefit for the school system. In fact, in the Texas case, the constitutional amendment and the redevelopment powers and tax increment financing was upheld over the objection of the school system. And here we have the school system agreeing and participating in it.
You said that you could distinguish DeKalb County, because I want to get back, let's say, to Georgia law here a little bit. And I don't know, maybe Mr. Johnson was going to address that, and if it is, I don't mean to, I'll let him do that. But specifically, where are the distinguishing characteristics between our case before us now and DeKalb County?
Three distinguishing characteristics. First, a constitutional provision that enabled the redevelopment powers clause. We submit that the trial court was correct in construing the redevelopment powers law as having constitutional dignity.
So
that's one distinguishing factor.
Are you then elevating that to a constitutional level?
We are, Your Honor,
All right.
but it's not necessary that you reach this result to affirm the trial court. The independent basis would be the fact that the school system here voluntarily pledged its increment. It negotiated a benefit, various benefits that it received for its participation. That's a significant distinguishing factor.
But it can't agree to do something that's unconstitutional, though.
Well, they can't, Your Honor, but the court must, as you well know, make every effort to harmonize one constitutional provision with another, a statute with a constitutional provision. And the language in the constitutional provision about necessary or incidental benefits to the support and maintenance of education provides the means to reconcile, to harmonize. And that is what the trial court did in this case. That's the means of harmonizing. But if this court does not believe they can be harmonized, we would say that the constitutional amendment, that is the Community Redevelopment Amendment, which enabled the redevelopment powers, which specifically allowed school systems voluntarily, when they considered it of sufficient basis to do so, to pledge their increment, that has constitutional standing. That amendment, although it appears in the 83 Constitution, along with the Educational Purpose Clause provision, is in fact a subsequent addition to the Constitution. The Educational Purpose Clause predated that. And as this Court's Hammond decision in 2011 says, where there's a later amendment that's entitled to constitutional dignity, it should be considered the last indication of the sovereign will of the people. So there are the three reasons we submit that this judgment should be affirmed. As to the other issues, we rely on our brief, and at this point I'd yield the rest of the time to counsel for APS.
Good morning. Mr. Woodham's argument regarding the school board's participation in the BeltLine TED is, first of all, based on a mistaken premise. His position is based on the assumption that you can sit here today and look at the city's redevelopment plan, pick out the amount of increment which is expected to materialize over the next 25 years, figure the school board's share of that projected number, subtract $160 million, and thereby arrive at an amount of increment which he says is being diverted from the support and maintenance of education. And that assumption is unfounded for a number of reasons. First of all, his assumption is of a quantifiable diversion erroneously assumes that the total amount of the increment is something that can be ascertained today, and that's simply not the case. We know that the BeltLine redevelopment area has not been subject to growth, and it's unlikely to grow without the TED. We know that the city's projections about the amount of the growth that will be generated with the TED are just that. They're projections about what might materialize over a period of 25 years. And the fact is that Mr. Assumptions about the amount of increment is in reality no more than an educated guess about what the city hopes may materialize. The fact is, over a period of 25 years, anything can happen to change the city's assumptions underlying its projections, from a recession or 2 or 3 recessions to a change in the city's priorities. Anything can happen to puncture the high hopes which are expressed in the city's projections. There's no greater indication of the risk associated with the city's projections than the fact that they're here today seeking to validate $200 million worth of bonds rather than $1.7 billion. Secondly, as the trial court noted, merely subtracting $160 million fails to account. $160 million is the pilot payments that we're going to get, and $10 million for the cost of constructing an athletic facility. That number fails to account for the other benefits that APS will receive over the next 25 years, and it doesn't account for the fact that at the end of that 25-year period, the school board will get all the revenues from what the city hopes will be generated at that time from the enhanced property values within the BeltLine. The fact is, it's not really possible to determine today the precise value of the future increment and compare that to the precise value of the educational benefits. And because Such of a comparison is so difficult, we have suggested that the principles developed under this court's gratuitous jurisprudence provides the most analogous framework for evaluating the bargain which the parties have struck. And that's what's involved in this case. It's a bargain. The school board, having determined that it would approach the subject of TADS in a manner consistent with its educational mission, struck a bargain on the BeltLine TAD. And under this bargain, the greater portion of the risk is apportioned to the city of Atlanta. If the city thought its projections were free of risk, they would be here seeking to validate bonds worth $1.7 billion, and they're not. The fact is that whether or not the BeltLine produces the revenues which meet the city's rosy projections and enable the city to fund all of its planned redevelopment costs, whether or not that occurs, the city still has a contractual commitment to provide these enumerated educational benefits. $150 million in pilot payments, $10 million for the erection of an athletic facility, $500,000 for a legal expense fund, developer contributions to an education partnership fund, additional pilot payments out of excess increment, land for the erection of athletic facilities, subsidized housing for teachers and staff. And as Atlanta's soaring housing costs make it increasingly more difficult to attract and retain quality teachers, this may be the most valuable benefit of all. The city's representative has said, and it's in the record, that these commitments are guaranteed. And so the school board has purchased the city's guarantee, and in return it's made a temporary loan of what is in the nature of an ephemeral expectancy. The unique nature of the bargain in this case is what makes it a case of first impression and distinguishes it from all the cases that have been cited to you in this case. Almost every case that's been cited to you dealt with an expenditure.
Did I miss, did you say the school system is making a loan?
It's an ephemeral loan.
It's an ephemeral. That's exactly right. Because at the end of 25 years, whatever the increase is, we'll be able to receive the benefits from in terms of current revenue at the end of 25 years. So to that extent, that expectancy is being parted with for a temporary period.
You're speaking on behalf of the city and also the school board, right?
I'm speaking for the school board. In the Ware County case, which we've cited to you, the school board had to write a check to pay for athletic facilities. In the Russell versus Fletcher case, the school board had to write a check to pay for crossing guards and to pay for garbage disposal. In the DeKalb County case, even the DeKalb County case, Justice Sears, the school board was being asked to write a check to pay for road improvements. And what they got in return could not be characterized as an educational benefit. So that's how I distinguish the DeKalb County case. They were being asked to make a current expenditure and get no educational benefit in return, which is not what happens here. As a matter of fact, in this case, the school board's revenues from the BeltLine project will be no less than what they've been in previous years, and the city hopes that the district will produce greater annual revenues in the future. And the only thing the school board is investing is part of this increased revenues that the city hopes will materialize, and that everyone has acknowledged will never materialize without the participation of these consenting jurisdictions. And so this is unlike what happened in any of the decisions that have been cited in the briefs. This case is most like the Savannah versus Hare case, where the school board paid a commission for the collection of school taxes, but the commission was beyond the scope of the constitutional provision authorizing the reimbursement of the collection of school taxes. And Justice Fletcher found that this excess over and above the cost to collect school taxes, which went into the general fund of the county, this profit that went into the county was a necessary and incidental public education expense authorized under the Constitution. So if it's acceptable under the Constitution to take money out of current tax receipts and pay them into the general fund of the county, as happened in Hare, it ought to be all the more acceptable to invest some future expectancy, which may or may not ever materialize in return for benefits which are more certain to materialize and which are clearly for the support and maintenance of public education. And that's what the Atlanta Board of Education did in this case.
Any additional questions? Thank you very much.
briefly, with respect to the Texas case that was referred to, when the court actually looks at that holding, it will note that it turned on the issue of whether a school system was a political subdivision, because the constitutional provision at issue in that case related to cities, counties, and political subdivisions. And the holding, the lower court said a school district was not a political subdivision. The Supreme Court said it was, and thus the constitutional amendment was deemed to allow school systems to undertake these activities. You'll note the Georgia Constitution refers only to cities and counties, so that definitely distinguishes the Texas case from the case now before this court. The school system puts forward this benefits gratuities analysis, which clearly ignores the core issue of whether the funds are being used for a constitutional purpose. You have to go back to Wright v. Absalom. The benefits is irrelevant. Are the funds being used for educational purposes? And if they're not, the Constitution of the state, the plain wording of the Constitution, and DeKalb County controls. The Community Redevelopment Amendment and the Enabling Act Redevelopment Powers Law did nothing to change the DeKalb County principles which control this case.
Any questions? All right, thank you very much. This court will take our mid-morning break. Thank you.
All right. Ladies and gentlemen, we'll get started again in about 5 minutes, so if you kind of like give us a little time. item?
Thinned out, didn't it? Yeah, it kind of got thinned out.
The second case for this morning is Tidwell versus Paxton, case number S0781306.
Ray Banks III for the appellant, James Aaron Dunn for the appellant.
You may proceed. Thank you.
Please, the court. My name is Rafe Banks. I represent the appellant in this case, Mr. Tidwell. This is an appeal from a habeas proceeding. The general question is the time period in which a committal or probable cause or bind-over hearing has to be conducted. The analysis, I would suggest, begins with the United States Supreme Court in Gerstein versus Pugh, in which they said that probable cause determinations concerning arrest without a warrant, and Mr. Tidwell was arrested without a warrant initially, that those determinations must be promptly made. Thereafter, the issue of what prompt meant came back to the U.S. Supreme Court in Riverside versus McLaughlin in 1991. And in that case, the court observed that under Gerstein, warrantless arrests are permitted, but persons arrested without a warrant must promptly be brought before a neutral magistrate for judicial determination of probable cause.
What's the remedy you seek?
What remedy do I seek? Well, frankly, in Mr. Tidwell's case, Mr. Tidwell's personal situation is moot. He has since been indicted, which I will concede eliminates the issue. But as we set forth in our supplemental brief, it is an issue that is capable of repetition. It's an issue that's capable of being avoided by indictment, and we respectfully suggest the court needs to address when.
But part of that principle also says it yet evades review. Do you think it meets that too?
That's correct. Because very few of these cases reach you for consideration. And it's a principle that affects every court, every county in the state, every sheriff's department, every police department, everyone that's arrested. The issue of when you conduct a probable cause hearing has vast and almost uniform application in the criminal justice system in the state. Riverside said, then accordingly, we left it to the individual states to integrate prompt probable cause determinations into the differing systems. Riverside went on to say prompt means 48 hours as a general rule. But the key is, the court also said flexibility has its limits. Gerstein is not a blank check. And interestingly, it's interesting when you go back and you read the entirety of a case that you've read excerpts from a good portion of your career. Riverside versus McLaughlin was a 5-4 decision by the U.S. Supreme Court in which they decided that prompt meant 48 hours. Interestingly, the dissent, led by Justice Scalia, wanted to say that prompt meant 24 hours, which I, frankly, until we got into this, I'd never read the dissent. Now, Georgia has addressed implementation of that promptness requirement. In fact, it addressed it prior to Gerstein and prior to Riverside through the two code sections cited in our brief, 17.426 and 17.462. 17.462 is the precise code section we deal with in this case, since this is arrest without a warrant. But those two code sections must be read together because they deal with arrest with a warrant, arrest without a warrant.
Mr. Banks, what do you suggest prompt means? Time frame, and I would
suggest means what the two statutes say. You get arrested with a warrant, 72 hours for a probable cause hearing. You get arrested without a warrant, 48 hours. We've asked the court for a bright line ruling that that's a clear ruling that that's what those two statutes mean. We concede that, and the statutes provide for a release from custody if those hearings are not conducted. No question that does not bar prosecution. No. I think it would also be appropriate for the court to recognize that in many instances, a defendant will ask to have that hearing continued from either the 48 or 72-hour requirement based upon the desire to obtain counsel, because this court has said that probable cause hearings, committal hearings, or however we term them, are critical stages. It's a critical stage in the proceeding, and you're entitled to counsel. Depending upon how far the court wants to go in setting out the guidelines and a bright line ruling we've requested, I would suggest the court also needs to address, if the defendant asks to have it continued to get counsel, what promptness means after the defendant requests to have it continued. I suspect the state will say, and in their brief they relied to a large extent upon a case from the 1960s from this court, Dodson versus Grimes. I would point out that that case was decided, although it was a unanimous decision, it was decided prior to Gerstein, it was decided prior to Riverside. The state also relies to an extent upon Powell versus Nevada, which is another in the series of cases from Gerstein to Riverside to Powell versus Nevada. All Powell versus Nevada did was say that Riverside applies retroactively. That was the holding of Powell versus Nevada. The facts in Powell really don't lend a lot to the analysis in this case. So Powell, nobody even got a warrant for the defendant's arrest until 4 days had passed. And I don't see that that lends a great deal to the court's analysis. The state also in its brief suggests that the obtaining of an arrest warrant satisfies the promptness requirement. Well, if the obtaining of an arrest warrant satisfies the promptness requirement of the probable cause judicial determination, why is every magistrate court, superior court in the state conducting probable cause hearings if that is sufficient to address the probable cause determination? Furthermore, the legislature has set out the legislative scheme of the two code sections that I cited, 17-462 and 26. If obtaining a warrant satisfies the probable cause requirement, the code section that deals with arrest with a warrant becomes meaningless. Why have a code section that deals with probable cause determination, committal hearings, release if you don't get it, if it's satisfied by the fact that you got arrested with a warrant? So we respectfully request that the court find that Mr. Tidwell, although in his case it may be moot, that he would have been entitled to his habeas relief because his hearing was conducted 22 days after his arrest. His committal hearing was scheduled, I believe, 41 days after his arrest. I would respectfully suggest both of those time periods are inherently unreasonable, despite the trial court's finding.
Did he get an appearance before a magistrate within the statutory time frame? Or
he did have a first appearance hearing. Okay. No question about that.
That was the next day after the arrest, wasn't it?
That is correct.
And he was informed of his right to an attorney and right to have a probable cause hearing and all this.
That's correct. And at the first appearance hearing, we tell people that you're entitled to have a probable cause hearing. But that doesn't satisfy the requirement.
Where's the weakness in the system? Is it the prosecutor or the sheriff or who?
Candidly, it probably depends upon the jurisdiction.
Yeah. We used to have a protocol that a lot of judges followed. I mean, I guess there's still a protocol out there about what to do when someone gets arrested.
In my experience, and I practice in a lot of jurisdictions, it's different in every jurisdiction. I haven't been to DeKalb County in a while, but I am informed that you don't get it in 48 hours. They open the door in DeKalb County. Other jurisdictions, you up in North Georgia, if you get it within 45, 60 days, you're doing well. And that's just my empirical experience. That's not in the record. But so on that basis, we'd ask the court for that bright line ruling. Because amazingly, there is no case that clearly sets this process out in Georgia. And it would save the courts, prosecutors, sheriff's departments, and the appellate system a lot of work. We can just define exactly what needs to be done and when it needs to be done. And I will reserve the remainder of my time with the court's permission. Thank you.
May it please the court, my name is James Dunn. I'm an assistant district attorney in the Beltline Judicial Circuit. And as Mr. Banks has already stated, the seminal case in this area is Gerstein versus Pugh, which is 1974 or 75 United States Supreme Court case. And the key, and I think what the petitioner in this case is confusing, is his first appearance hearing and his committal hearing, his preliminary hearing. And Gerstein is clear. In Gerstein, when someone is arrested without a warrant, that they're entitled to be brought before a neutral fact finder, in most cases a magistrate, and then that magistrate is to pass upon probable cause at that point in time. And it's just probable cause as to whether they should be detained at that point in time, as this court is well aware. In County of Riverside, they put the actual time limit. They gave the bright line rule. They said that was within 48 hours. But if the part that the petitioner of Gerstein that he completely ignores is Gerstein, a large portion of Gerstein, they talk about that this is not an adversarial proceeding, that this first appearance hearing does not have the rights of confrontation, does not have the rights of cross-examination, that it's not an adversarial proceeding. And that's why that it's so prompt that it's within the 48 hours. And the United States Supreme Court is very clear in how they term that, because they know different states term, preliminary hearing, even in Georgia, preliminary hearing, committal hearing, commitment hearing, probable cause hearing, that has different terms. But they say, and if you read the opinion, it's probable cause determination. And that's exactly the terminology that is embodied in the United States Supreme Court law, but it's also embodied in this court's law, the Supreme Court, and also the official code of Georgia and the Uniform Superior Court rules. OCGA 17-4-62, which is the code section that's at issue here, states, in every case of an arrest without a warrant, the person arresting shall, without delay, convey the offender before the most convenient judicial officer authorized to receive an affidavit and issue a warrant, as provided for code section 17-440. No such imprisonment shall be legal beyond a reasonable time allowed for this purpose, and any person who's not brought before such judicial officer within 48 hours of arrest shall be released. And it's clear from reading that it's talking about a first appearance hearing. That if someone needs to be brought before the magistrate within 48 hours, and that's their first appearance, and if there hasn't been a warrant issued at that point in time, that the magistrate is to hear from an officer testimony and issue the warrant. And in this case, Mr. Tidwell was arrested on February the 14th, around between 6 and 7 o'clock in the evening time, and the warrant was issued the next morning around 10 o'clock. He also had his first appearance hearing at that time, where he was notified of his commitment hearing. Uniform Superior Court Rule 26.1 in subsection E states, and this is talking about first appearance hearings, that in the case of a warrantless arrest, make a fair and reliable determination of probable cause for the arrest unless a warrant has been issued before the first appearance. And there again, that's the probable cause determination that has been was envisioned in Gerstein versus Pugh. The other code section that Mr. Banks alludes to is OCGA 17-426, and that talks about when someone has been arrested with a warrant. Well, in that case, they have 72 hours at that time to bring that person before a magistrate. And in that code section, it doesn't say anything about a finding of probable cause. Well, why is that? Because there's already been a warrant issued. There's already been that initial probable cause determination, as the Supreme Court uses in Gerstein.
Can somebody get a bond in your circuit before a warrant's issued?
can someone get a bond in our circuit before a warrant is issued? Generally, if it's set by schedule, yes, I believe they can.
So you're not sure?
I'm not sure exactly on that. Generally, they issue the warrants within the next day. We generally don't have a problem with them not issuing warrants within 48 hours. And as soon as they issue the warrant, if it's bondable by the magistrate court or bondable, if it's bondable by the sheriff's schedule, that they can bond as soon as they're put into the jail. But if it has to be bondable by the magistrate, then they will get a bond at that time, at their first appearance.
Can they get a commitment hearing if they get a bond?
Yes, our magistrate court, as long as they ask for a commitment hearing, even if they get a bond, then they generally will give them a commitment hearing. And again, this court has interpreted, again, with 17-426, the 72-hour requirement being brought before the magistrate, that code section makes it clear that the reason they're to be brought is so that their commitment hearing can be set. And that's it. There's no mention of a finding for probable cause because that initial probable cause determination has been made. OCJ and this court in Dean versus the state at 250 Georgia 77 held that OCGA 17-462 does not require that a full adversarial hearing be held following a warrantless arrest, but merely seeks to ensure that the arrest and continuing detention of the accused is reviewed by a neutral fact finder and is satisfied where the police obtain an arrest warrant within 48 hours of a valid warrantless arrest. And so really what the petitioner is asking for is a full-blown committal hearing when he's entitled to the first appearance hearing. I mean, it would just, all the law that this court has made, and even OCGA 17-462, basically they're asking that it just be null and nullified, that we not have any kind of first appearance hearing. Well, it doesn't make sense not to have a first appearance hearing when it's embodied by the law. The other issue that petitioner, they should be careful what they're asking for. And most, if someone was to get a full-blown commitment hearing with adversarial rights within 48 hours, most attorneys for a defendant, unless they ask for it to be continued, they're not going to be prepared. And they're not going to have been able to get any kind of police reports, because probably within 48 hours there are no police reports. They're not going to have been able to talk to any witnesses or subpoena any witnesses that the defendant may have given them. The only thing they're going to have been able to do at that point in time is talk to their client and find out their side of what's going on. And again, for there to be any kind of meaningful confrontation rights, meaningful cross-examination, there's no way for the court to say that there has to be a full adversarial preliminary hearing within 48 hours. And that's recognized in Gerstein versus Pugh. They say that it would be almost next to impossible to have a full adversarial hearing.
From your argument, addressing the merits, I assume that you agree with counsel for the appellant that this meets the exception to the mootness and that we should decide this case?
Your Honor, I don't believe that it meets the exception to the mootness. No, I was getting to that. I believe basically that he could have raised it at the time. As soon as the petitioner was incarcerated at that time, he could have filed the habeas. As this court well knows, the habeas hearing has to be set within a specific short amount of time. The hearing could have been held within a couple days, and then it could have come to this court's attention at that time. So I would state, and I did file a motion to dismiss on that ground, that since there was an indictment, that this issue is moot. I think it's important for this court to know that in Hunt versus Hopper at 232 Georgia 53, this court held that there is no constitutional right to a commitment hearing. And in that case, the court was talking about the adversarial commitment hearing. Along with that is State versus Middlebrooks 236 Georgia 52, that a preliminary hearing is not a required step in a felony prosecution. And Watts versus Pitts at 253 Georgia 501. In that case, this court held that if you post bond, that waives your preliminary hearing. And they said, this court stated that in Georgia, a commitment hearing, if held, is a critical stage in criminal proceedings. And the key phrase there being, if held. And that's what the United States Supreme Court has never held, that a commitment hearing with full adversarial rights is a constitutional right. Only in Gerstein did they say that this initial appearance, this first appearance hearing, that is a constitutional right based in the Fourth Amendment for a person to be free from an unlawful seizure. And this court has previously held that a preliminary hearing is not, there's no constitutional right for a preliminary hearing. And that's why if they post bond, they can waive a preliminary hearing. Because if it was a constitutional right, forcing someone to waive a right by posting a bond, that would be unconscionable and untenable. And therefore, based on the arguments, the case law that is clear under Gerstein, the official code of Georgia, and the case law of this court, I would ask that you deny petitioners, that you would just uphold the petition, the trial court's ruling for the petition of the results.
Please, the court, first let me make it clear. We are not asking for full-blown adversarial hearings. We are talking about probable cause hearings. Hearsay is admissible. Hearsay is dealt with in probable cause hearings. The state doesn't have to bring all of their witnesses. It is not a full-blown adversarial hearing. And I don't suggest that that's what a probable cause hearing, and that's not what we're dealing with today. But what is important is we are talking about committal hearings. We are talking about hearings. You read all of the cases, and they speak of hearings. I'll note that the state hasn't, apparently, nor have I found any case in any jurisdiction that says obtaining the warrant satisfies the Gerstein or Riverside requirement for a judicial probable cause determination. All of the cases talk in terms of hearings, even Riverside.
We have said, though, that going before a judge and having the date set within 72 hours meets the requirements, even if the hearing takes place.
That was in Dodson versus Grimes, I believe,
right,
which is the case from the 1960s, which I would suggest is of no effect now in light of what Gerstein and Riverside say about promptness. Because in that case did say, as long as you schedule it, everything's fine. But I'd suggest Gerstein and Riverside changed that. Even in Riverside, Justice Scalia in his dissent, footnote 2 says, ordinarily I think there would be plenty of, remember, he wanted 24 hours. Ordinarily I think there would be plenty of time for administrative steps while the arrangements for a hearing are being made. But if, for example, a magistrate is present in the precinct and entertaining probable cause hearings at the very moment a wrongfully arrested person is brought in, I see no basis for intentionally delaying the hearing. Well, hearing is a two-sided animal. You don't have a hearing when the cop goes in and gets the warrant from the magistrate. That's not a hearing. A probable cause hearing is somewhat short of a full-blown trial. It's not a full adversarial hearing, and I don't suggest it is. But constitutionally, it is required.
I think we've got a real problem with terminology in this case.
I believe we do. Absolutely. We do not seek in...
if there are two sides, it's an adversarial hearing. You say it's not, but it is, and that's what you say you won't.
Well, a probable cause hearing, particularly when this court has said it's a critical stage and the defendant's entitled to counsel in a committal hearing, that's Gresham versus Edwards. The site escapes me. That is a committal hearing issue. It is short of a full-blown adversarial hearing because there is no right of confrontation. Hearsay is admissible. No dispute about that. But all of the cases, from Boyd versus St. Lawrence, which is cited in our brief, talks of commitment hearing.
What about Dean versus State?
Dean versus State.
It says 17462, which is the code section involved in this case, is satisfied where police obtain an arrest warrant within 48 hours of a valid warrantless arrest.
Not familiar with the case. The site for the Gresham versus Edwards is 281 Georgia 881. It's a 2007 case. State cited State versus Middlebrooks. That case talks of, it's from this court, overruling the Court of Appeals. Gerstein versus Pugh sets forth in clear and unambiguous language the Fourth Amendment mandates pertaining to pretrial hearings. Gilstrap from the Court of Appeals at 230 Georgia Appeals 281 talks in terms of probable cause hearings. Case from the Northern District of Georgia, Judge Story at 376 Fed Sup 2nd, page 1340, Powell versus Barrett, talks about Riverside, Pew, probable cause hearing. Every court that addresses it talks in terms of hearings. Supreme Court of New Jersey, the State versus Tucker, at 645 Atlantic 2nd, 111, talks in terms of probable cause hearings when they refer to Gerstein and Riverside.
And just help me make sure I understand. Your contention about the order of events, is that more directed by the United States Supreme Court's interpretation of the Constitution or their rulings on the Constitution, or is it more directed by the express statute that's in play?
Frankly, it's a combination. There is an overlying constitutional requirement for promptness and probable cause determinations. It's specified as 48 hours in the case of arrest without a warrant, somewhat like the implementing legislation from the prior argument. Georgia has two statutes which implement that requirement. One in the case of arrest without a warrant, one arrest with a warrant. And I will concede that if you're arrested with a warrant, 72 hours is probably reasonable. The U.S. Supreme Court hasn't addressed, to my knowledge, arrest with a warrant, what's reasonable for a probable cause determination.
So if we look at the statute and look at each individual requirement and see where those requirements are checked off, are there other requirements that we need to read into the statute by way of the Constitution, or is the statute constitutionally sufficient in and of itself?
I would suggest the statutes are constitutionally sufficient in and of themselves to implement the constitutional requirements. Interestingly, Georgia has even provided for the remedy, which Riverside didn't address, and which Powell versus Nevada was remanded for the Nevada court to make a determination of the appropriate remedy. Georgia's already decided the remedy, which is release. Thank you.
Thank you. All right, the third case for this morning is Lafont versus Rouvier, case number S07F11422.
Michael Eric Manley for the appellant, Amy Embry McChesney for the appellate.
All right, these are pilot project cases limited to 10 minutes aside.
Good morning, and thank you for the pilot project and giving us the opportunity to bring this case before you. Of course, this case is based upon an abuse of discretion. The standard before the court is whether or not there is any evidence, and our argument today is that any evidence cannot mean scant evidence. Any evidence cannot mean a mere rationalization. It cannot mean making up facts out of whole cloth, such as we have in this case, the conjuring up of ear infections, the allegations of cocaine use, the appellee's response to the Hague Convention action brought in France. There is oversight provided by this court through the pilot project, but for there to be oversight, it must be meaningful oversight, to have any oversight at all. Otherwise, this court becomes little more than a rubber stamp in family law cases, merely affirming rationalizations. Your Honors, I ask that we have integrity in the process, and even more importantly, or perhaps as importantly, that we have integrity in the result, so that this court can provide oversight to the trial courts to help provide some uniformity in result. Anybody sitting through this court, through this trial, I maintain, would have come to a different result. Any rational finder of fact, anybody looking at the witnesses who testified, the documents who were presented, the history of the case, you'd had to have been deaf, dumb, and blind to come up otherwise, or, I think in this case, perhaps heavily biased. Heavily biased that somehow or another necessarily it must be better for children to be with women than with men. That is the bias, I believe, of the trial court, and all else was rationalizations. To be able to determine the truth of that, all this court needs to do is, of course, look at the transcript, which bears me out, and we've cited ample evidence to the transcript, but also the court's interim order. And remember that this is the case where a little girl was taken off to France by her mother, who refused to return. According to opposing counsel, who told the trial court in his motion to withdraw, my client tells me she is not coming back. And she was finally brought back through the Hague Convention. And in the interim order, we had the result that we had. However, 29 days later, the trial court flip-flopped completely, and instead of in the interim order, the court had determined that the father would have primary custody, that the father will make decisions, that the mother's actions in hauling off to France was in direct violation of the court's order, that the mother's actions had prevented the father from exercising his custodial time. Further, that the mother's actions were so egregious that her visitation was going to be supervised. And that's pretty onerous for the trial court to have come to that decision. Further, the court in the interim order referenced that he had spoken to the child twice and talked about his findings from speaking with that child. He said, in assessing the child's demeanor, language, manners, and actions from his conversation with her on November 27th, he noticed a distinct difference from his conversation with her back in April. And that difference was not positive. Of course, the judge did not speak with the child between his interim order, which was within hours of the conclusion of the trial of this case in November 2006, and when he entered his final order on December 29th of 2006. The court in the interim order said, it appears that a concerted attempts at alienation by the mother during the long stay with her are evident. That was the interim order.
Let me ask you this. In your application that was granted on the pilot project, you seem to contend that the court violated Superior Court Rule 24.5b with regard to talking with a child. Do you still contend that?
No, sir. No, sir. For all the world, in my recollection of the trial, I did not remember ever saying, okay, Judge, I had said, I want to be there, and the court said, well, I'm not going to allow that. My recollection was I'd never said, okay, then go ahead and talk to the child. When we got the transcript, I was in error on that. According to the transcript, I had finally said, yes, sir. If it means talking to her or not, I'll waive my objection to it. So that's why that did not make it to our final brief. I was wrong about that in the application. 29 days later, in the judge's final order, thank goodness that the judge did give us findings of fact, because I had not requested findings of fact. The judge found that the special bond existed between the child and her mother. An extensive amount of time that this child spent in France was cause for sending this child to France with her mother. That the child had bonded to her mother's nuclear family, and that the mother had been the primary caretaker of the child, and that the child had a special relationship with the mother's extended family in France. So when you juxtapose that with the court's interim order, you have to wonder where this came from, particularly in light of the transcript, that there was no evidence of these special bonds, not to mention the fact that the special bond with extended family is not cause for determining custody, that this extensive amount of time argument has to do with, I think it was 1/6 of the child's life spent in France versus the rest of it. This is a United States citizen, this child is, a Georgia resident, for all the time that she had spent in the United States. What the appellee wants to do with the any evidence standard is to grasp at straws and to stay off subject, not stay on subject on the 5 findings of fact that the court entered in its final order. So you look to the transcript and you look to the interim order. Within the context of the transcript, appellee brought an expert, Dr. Robert Alpern. And it's important to note that in cross-examination, Dr. Alpern said something that I haven't heard an expert say before, but he admitted to us that he was nothing more than a Washington spin doctor, that he was spinning his clients' tales to suit his clients' purposes and nothing more. Within his findings, however, he did identify that appellee fit the classification of histrionic personality traits. He further went on to slander all Southern women by saying, well, he generally finds that's true of Southern women. Of course, the appellee in this case is from France. Further, that she was negativistic, passive-aggressive, and she had sadistic personality features. When asked on cross-examination, I believe this was by the guardian ad litem, he admitted that the appellee had used poor judgment and acted irresponsibly, and that irresponsibility alone may be enough to warrant not allowing the child to live with her mother. But his bias bared out on here more than just the Washington spin doctor. He opined that from a 5-year-old little girl's vantage point, living with her mother makes more sense. That is the bias that was throughout the case. All else in Dr. Alpern's testimony was rationalization, and it requires meaningful oversight by this court to be able to render some meaning to the pilot project. The appellee had several important quotes in her goodbye letter. She talked about being at war with the appellant, and in many cases that's the case. I mean, War of the Roses we certainly know about. But specifically in this letter, she talked about using her daughter as her weapon. In her Hague response to the French authorities, she did not mention her suicide attempt. She did not mention that she was supervised the entire time from her suicide attempt until the time that she fled back to France by her parents, who were here the entire time. She told the French authorities that she had sole custody. She did not. According to the emergency order that was entered by Judge Watson White, the father had sole custody immediately after the suicide attempt. Later on in April, when there was another hearing, the father had implemented a 3 days on, 3 days off agreement because the mother's parents were there. He felt it was fairly safe with the parents' supervision. Judge Nix implemented that. So at best, when she filed her Hague response, she had a 3 days on, 3 days off agreement, never sole custody. And perhaps even most egregiously, she told the French authorities that the father only had supervised visitation. She lies to every court. She lies to every authority that she has the opportunity to lie to. And this is in the best interest of the child, and this is behavior that we want to reward.
What is the contact that the father has had with the child since this order?
Sporadic. It has been within a few days of the judge's visitation schedule. It has always been rather torturous to try to get that in, so there have been a couple of days lost on the front end generally in trying to get last-minute arrangements made. There has been visitation roughly along the schedule of visitation provided.
Does the father go to France, or does the child come to the United States?
The child has come to the United States. I believe that the father is going to France for the October visitation schedule at this point. The child has been here twice, I believe, since our final hearing, which, considering that what the child told, looking for that, what the child said right after she was back with her mother was that she was never coming to America again and she would never see her father again. So, fortunately, that is not the case, but it is tortured, and after this court's decision, should it not be favorable for the appellant, there is no telling. It has not been the history of the mother to allow that kind of contact without a lot of effort. The guardian found, or recommended, of course, that the appellant have custody, that it was not in the child's best interest to return her to France. And you remember, this was after that month where the appellant had custody of the little girl, and the mother refused to see her, refused to have anything to do with her, until, fortunately, the appellant's attorney arranged for a supervisor for that visitation. Otherwise, it wasn't going to happen. No clothes were exchanged, nothing, no contact, except for telephone. And so the guardian observed that the appellee was engaging in the same histrionic negativity that kept the child from her father for 4 months in violation of this court's order. And she saw that the appellee was still using the child, willing to use the child as a weapon, and apparently had no remorse in doing so. So without any shred of evidence and absolutely devoid of reasoning, the trial court flip-flopped on December 29. And so I think it's fair to ask that before this trial court, can men get equal justice in family law? It was particularly egregious to me that the court didn't talk about fitness of the parents. To the court, the fitness of the father was irrelevant. He was irrelevant.
Thank you very much.
Thank you.
May it please the Court. My name is Amy Hembry McChesney, and I represent Sophie Roviere, the appellee in this matter. At issue, of course, is the physical custody of 4-year-old Madison Lafont, a child born in the United States of French parents, who is, because of that fact, eligible for dual citizenship here and in France. We're all familiar with the story of wise King Solomon, who, by offering to cut a baby in half, discerned which of two women claiming him put the child's best interest foremost. In this case, while both Madison's parents undoubtedly love her and are fit to assume her custody, appellate Raphael Lafont elevates his own interests, expectations, and desires above Madison's and he lacks the moral fiber and emotional strength to provide her with an appropriate model. He's an admitted serial adulterer who left his daughter with her mother to pursue his own pleasures with his mistress openly. Not only that, but immediately after his distraught wife admittedly dramatically attempted to regain her child's father by overdosing on minor tranquilizers, he took Madison from her home and the nurture of her relatives and placed her in the charge of his mistress, who was a complete stranger to her. At the temporary hearing, Lafont testified that he would not return to France to be near his daughter, even if his wife obtained physical custody of her there. He changed his mind at the final hearing and said that he would go back to France if she were awarded physical custody. On the other hand, Sophie Roviere, having fully recovered from the emotional carnage caused by her husband's flagrant adultery, is willing to sacrifice her all, including her dreams of living in America, to assure her daughter's welfare. In Georgia, Solomon's ancient task of deciding contested child custody lies squarely upon the shoulders of the judge, who can see and hear the parties and their witnesses, observe their demeanor and attitudes, and assess their credibility. That's Weichert v. Weichert, 268 Georgia Appeals, 624, a 2004 case. Like Solomon, the trial court is vested with very broad discretion to resolve child custody issues contested between parents, guided always by the best interest of the child. Urquhart v. Urquhart, 278 Georgia, 548, 2000. Where the trial court exercises its discretion and awards custody of a child to one fit parent over the other fit parent, this court will not interfere with that decision, unless there's evidence that the trial court clearly abused its discretion. And that's the Anderson case at 278 Georgia, 713, 2004. In other words, as the appellant admits in his brief, the evidence must demand a contrary verdict. He admitted that when he cited Weaver v. Weaver, 238 Georgia, 101, a 1976 case. But where there is any evidence that supports the trial court's decision, it cannot be said that there was an abuse of discretion. And any evidence means any evidence. It does not mean that just because there's evidence you can disregard it. It means any evidence. It means exactly what it says. Furthermore, when reviewing any bench trial, this court will not set aside the trial court's factual findings unless they're clearly erroneous, and this court properly gives due deference to the opportunity of the trial court to judge the credibility of the witnesses. And again, this is based on the standard of review cited in appellant's brief, Frazier v. Frazier, 260 Georgia, 687, a 2006 case. In other words, as Justice Melton repeatedly reiterated in Bloomfield v. Bloomfield, which was decided by this court June 4th, 2007, in S070096, this court cannot act as trier of fact or reweigh the evidence. Instead, being mindful of the difficulty of the trial court's task, this court will defer to its credibility determinations and accept its decision so long as there is any evidence to support it. Before we examine the evidence in this case, however, this appeal must fail as a threshold matter because of Lafont's procedural defaults. For two reasons, Lafont cannot affirmatively demonstrate any error at all. First, he waived findings of fact. That's at transcript volume 745 and to 746. Second, he failed to provide this court with a transcript of the trial court's interview with Madison, either of her interviews.
Was a transcript made?
I beg your pardon?
Was a transcript made?
Not to my knowledge.
It was reported but not transcribed, right?
It was, and there was in fact a court reporter present, Your Honor. There certainly was the availability of asking that it be reported and transcribed and brought to this court, and certainly her testimony would have been material to the issue of her best interest and material to the issue of how she felt about the bond with her mother, the bond with the extended family in France, about the time that she spent there. We only have conclusory statements in the court's orders about its impressions that the child had become alienated from her father, but we don't know whether, as Dr. Alpern said, that was because of the situation where she was ripped from the arms of her mother, who had been her primary caretaker for the majority of her life while her father worked in the restaurant industry and only saw her a few hours each morning. and the disruption of her family, and the fact that her father tried to conceal the fact that they were even separated when he left to live with his mistress. And he came back every day to see her in the morning, but the child very quickly realized he was not living there anymore, and she had questions for him, and she wanted to know where he was and what was going on, and the child was very disturbed. And he tried to answer her as you would answer an adult. He did not address her emotional concerns. He was never concerned about this child's emotional well-being. He was only concerned about his wanting to go and live with his mistress. When his wife went to France, as she habitually did every summer with the child, and worked because she did not have a work visa here, with her family in France, and earned a living and earned extra money and sent money home here to him, he was out popping into bars and making passes at women. And the evidence disclosed that during one of these visits, he met Diane Foster, who drank to excess and has an adult daughter who did not even get a high school education. Yet this is the woman he chose to put Madison in charge of.
It seems like we're getting somewhat afield. I mean, there's a rationale articulating the trial court order for the decisions made. I haven't heard either side articulate what was right about the factual findings in the trial court order, or what is wrong with the factual findings.
Well, the problem, Justice Melton, is there are very scant factual findings because the parties waived factual findings.
The ones that are in the order?
And yes, the ones that are in the order are accurate, so far as we can tell. The problem that we have here is that the court, since it was not required to make factual findings, may have relied on facts that were presented that were not set out in the order because it was not required to set them out. The factual findings that were made, however, as I point out in my brief, are substantiated by the evidence. There was evidence of a bond between the mother and the daughter, and I have gone through that extensively. First of all, the mother testified that that she was the primary caretaker, that she loved her daughter, that she took care of her. She had an expert who testified that she was the primary caretaker, that the daughter was oriented toward the mother as her primary caretaker, and that it would be very harmful for her to be left here in America and her mother go back to France, as she had to do because she did not have a work visa. It would be very harmful to her. It would also be very harmful to the mother-daughter relationship if she were to continue to associate with Diane Foster. And he felt that that was very confusing to a young child, to have the father show affection to a woman who was not his mother, the child's mother, in her presence. And there is even a photograph presented by Lafont where he is having the child kiss Diane Foster on one cheek while he's kissing her on the other, and then presented that to the court. So certainly there was the fact that the child lived there under the same roof in a meritorious relationship immediately after he contends that his wife forced him to put her in that situation is certainly not a good emotional environment for the child. It was very confusing to her, and both Lafont and his paramour admitted that the child continually asked, "Where is my mommy? Where is my mommy?" which prompted Lafont to start taking the child for visits to her mother. And on one of these occasions, the child kicked and screamed visibly when he tried to take the child away and said, "No, I'm not leaving my mommy," and he left her there. And that's when he said to her, "Okay, let's have 3 days on and 3 days off," admitting that she was a fit parent. Let's have 3 days on and 3 days off, but don't tell the lawyers. Don't tell the lawyers. And so they began to split.
It still seems to me you're arguing other facts that we don't need to retry. There are certain facts that are in the trial court order. Either those facts are right or they're wrong. That's all we need to know, I think.
Well, Your Honor, there certainly was evidence of a bond in that Rovier testified that every summer the child went to France with her, that she had a bond with her father, the grandfather of the child, and her grandmother, who worked with the mother over there, that there were pictures and there was testimony about other relatives, nieces, aunts, uncles.
I don't want to get retrying all this other stuff. We're not in trial court. We're getting too into the...
I understand that. I understand that, Your Honor. That was one of the very few factual findings that the court made, and of course there was evidence of it.
Thank you. Thank you very much. The last case set for this morning is Bucciao versus Bucciao, case number S07F1075. How do you properly pronounce that?
It's Banshee.
Banshee, sorry about
That's all
that.
right.
Okay.
All the time.
Okay.
Good morning. My name is Mary Provula, and along with Florence Vital, I represent Alexander Banshu, who is the appellant in this case. We're here today on 4 enumerations of error from the trial court. 2 of those involve the award of retroactive child support and retroactive alimony. The appellee in her brief apparently concedes that it was error for the court to award retroactive alimony and retroactive child support, although she does contend that this was a clerical error.
That's what the assertion is just simply incorrect dates put forth in there.
That is the appellee's assertion. We think that the facts belie that, in that this order was submitted in November or December, and clearly their request was that it go back to October. But the fact that they have admitted that it is error indicates to us that the court should reverse, and we request that the court include a ruling in that. Surprisingly, there is no case law in Georgia that we could find that says a court may not, on an initial finding in a divorce, order retroactive child support and alimony. It's clearly axiomatic that the order cannot be in effect until it is entered, but there's no case law supporting that. There's plenty of case law supporting that you can't do it in a modification, but we'd request the court enter a ruling on that. Turning to the issue of improper imputation of income.
Could the court do it nunc-pro-tunc? Back to the date of filing?
Could the court enter at child support and alimony nunc-pro-tunc as of the date of filing? Based upon the child support guidelines in effect when this case was resolved, we believe the answer is no. There is at least some information, some suggestion in the new child support guidelines that that might be possible now. But under the guidelines in effect, as of the date of this judgment that was rendered, we believe the answer is no. And in this particular case, we believe the answer is no for an additional reason. There was already a temporary order in this case. In that temporary order, the court had set a figure for child support. The appellee had, in fact, on the record, waived her right to alimony in that temporary order. So by putting in a retroactive date in the final judgment, the judge, in effect, ordered or changed his temporary order retroactively. We believe that's impermissible under all the modification cases which we've cited in our brief, not the least of which the court is, I think the court is aware of those, but I can cite them if you like, Butterworth, Robinson, et cetera. So we think the court cannot do that. With regard to imputation of income, in this particular case, the court did not properly follow the child support guidelines in effect at the time in order to impute income or determine an earning capacity different from actual earnings. As this court is aware, under Eldridge v. Ireland, 259 Georgia Appeals 44, and Eubanks v. Rabin, a March case this year, 281 Georgia 652, which is consistent with the earlier 2002 Eldridge case. The starting point for determining gross income under the child support guidelines is the actual earnings of the father. In this case, the court never even looked at that. In fact, there is no finite finding of even earning capacity in this case. The court found in its order the gross income of the father is at least $90,000 annually or $7,500 monthly approximately. There's no concrete finding. We submit that under Eldridge, this case must be reversed on that point. Eldridge was very similar to this case. In Eldridge, the father was in a family business. His income had declined because the family business had not obtained certain contracts. He submitted tax returns that showed his declining income for several years.
The court in Eldridge entered a finding that the father had an earning capacity of $45,000. That figure bore no relationship to any evidence in the case. The court did not follow the guidelines in first determining actual income, then considering the factors under the guidelines which would allow the court to impute income. In this case, we have an even more egregious situation. First, the court did not determine actual income, but second, he didn't even find an actual figure for what he thought earning capacity was. We contend that the fact that the appellee, even in their brief before this court, argues a different number for appellant's income. They argue $75,000 in their brief. I believe it's at page 11. Page 21, pardon me, page 21. Shows that the court had no basis for entering this figure. We also submit to the court that even though the court may use its own experience in determining earning capacity, it must still be based on the evidence. There is no evidence in this record that Mr. Banshew made any more than $48,000 a year. He submitted his tax returns. He submitted a domestic relations financial affidavit. He submitted an additional affidavit when his income went up. And he submitted his corporate tax returns, which showed losses. The only thing that appellants cite in their brief is a string of information that they say shows he made more money. But if the court will carefully review that, you will see there are no record sites. And the reason there are no record sites supporting that argument is because they do not exist. That evidence was not before this court. Instead, what happened, this court was asked to take judicial notice that he had a construction business and he should have been making more money. Even the guardian ad litem said take judicial notice. The court knows under Eubanks versus Raymond, you can't take judicial notice of actual income, you have to prove it. The appellant's counsel urged that the court could find that, well, you know, he's got to be making a lot more money. You can see all these comments throughout the record. That is not evidence, and this court could not do what it did. Further, the court did not go on and make the appropriate findings that would allow this to have been an earning capacity case. It did not, once it established gross income, it did not look at the other factors that can be considered under the guidelines to determine earning capacity. Then with regard to child support, he improperly looked at, which is our third enumeration of error, he improperly looked at the guideline figure for one child. In this particular case, there are 3 children at issue in this family. 2 of them are living with Mr. Banshew. Mr. Banshew has custody of those 2 children. Mrs. Banshew has custody of 1 son. The court properly found on the same page that the proper percentage for 3 children is 28 to 32%. Who was awarded custody of those children, the 3 children? Mr. Banshew has custody of the 2 older boys, and Mrs. Banshew has custody of the younger boy per agreement. So once the court made the proper percentage finding, he then deviated from that without the appropriate findings of fact. He instead ordered Mr. Banshew to pay 25% of his gross income, which, by the way, exceeds the guidelines for even 1 child, to Mrs. Banshew, with no corresponding order for Mrs. Banshew to support her children. The 2 children in Mr. Banshew's She makes $325 a month. How can she hardly support herself, much less contribute child support? Well, in that particular case, we submit that the court's finding of $325 a month was erroneous as well. There is evidence of the record that Ms. Banshew was deliberately suppressing her income. We have cited that exchange in our brief. She particularly said that she did not feel she had an obligation to support her children. Her answer to that question was no. She said she was not going back to work despite the fact that she had worked in real estate, and there was evidence that 10 years ago she made $11 an hour, which would be $1,900 a month. She also testified she'd worked at Burger King $8 an hour, which would be approximately $13.50 a month. But she was not going back to work. We submit that those 2 children are entitled to be supported by both parents under the statute. I'd like to reserve my remaining time.
Okay.
Good morning, ladies and gentlemen. I'm Mark Lang, and I represent the appellee, not the appellant, the appellee, Ms. Estera Banchu, who was the plaintiff or the defendant in the underlying case. First off, Your Honor and Your Honors, I agree with Judge Carley that there was a clerical error, that the court in the matters of the child support commencement date and the alimonial commencement date was a clerical error. And that's what I cited in my brief, and that's what I concede today. But it was not an abuse of discretion. We're not asking for retroactive child support. We're not asking for retroactive alimony.
Who drafted the order?
Judge Batchelor drafted the order.
Right.
Judge
So
Hudstein.
neither attorney drafted the order.
If you look at the transcript, the judge asked me for a floppy disk because I had proposed a order back in August of 2006 based upon an agreement between the parties at a prior trial call. However, the appellant reneged on that agreement, and we had to go to a trial. And we had a trial specifically on the 4 issues that we have, or on other issues that are not before this court, and it's in the transcript, and I direct this honorable court to look at the transcript. So we had a trial on specific issues, one being child support, one being alimony, some issue as to the cost of transportation of the visitation, division of 3 pieces of real property, and that was it. The parties had already agreed to divorce. They had already agreed to this custodial arrangement. And so the trial that was held in November of 2006 was on those limited points. I agree, the appellant agreed and admitted at trial that the appellee should receive child support. The appellant agreed at trial and agrees in the brief that the appellee is entitled to alimony. There's no evidence at trial, in the transcript, in my briefs, in any of the documents that are filed with this honorable court that the appellee was seeking retroactive child support or retroactive alimony. It is a clerical error. And it could have been resolved, Your Honors, prior to this case being appealed by the appellant making noise such as a motion or asking the court, is the court correct in the commencement date? And prior to the appellant filing this action, the court most likely, with my consent as well as my client's consent, to use a date subsequent to the trial date. And the trial date was, I think the court order was December of 2006. And that's all the appellee is asking for from this honorable court, and that's a trial.
What do you say about the proof of income of the father?
Well, as to the, again, the appellant is not disagreeing or disputing that the appellee is entitled to child support or alimony. That's admitted. The whole question is, the appellant is the amount. And the amount is based on 2 things based upon the trial court's order, and that's imputed income and shared physical custody, or supposedly special circumstances. And the special circumstances the court made a written finding was the disparity of income as well as the shared physical custody. These people have 50% of these children. They have joint legal and joint physical custody of these 3 children, of these 3 boys. The guardian ad litem, as well as the parties, as well as the court-appointed psychologist, recommended that these children spend 50% or as much as 50% with the 2 parents.
That's fine, but where's the evidence to impute $90,000 income to the appellant?
First of all, they cite in their brief his domestic relations finance affidavit. He filed 3 separate ones. At trial, if you look at the transcript, I impeached his financial affidavit. His business is his alter ego. His business made in the last 3 years prior to the divorce in excess of $750,000, $500,000, $600,000. He uses the business to run his income, to engender his income, and to hide his income through his business. He's bought autos. There's evidence that he bought autos through the business. His expenses are inflated to hide revenue and profit earned by him. He purchased real property. This man reported to the IRS, the appellant reported to the IRS $36,000 a year on his tax return. He accumulated in 5 years 7 pieces of real property, including a condo in Aventura, Florida, 2 pieces of property in Port Charlotte, a property in Flowery Branch, 2 residents, as well as a quadruplex. Now, if you look at the transcript,
You know,
plus, Your
when
Honor.
I was trying cases, I was just going to
I
ask
understand.
both sides this. Did anybody just ask to look at Schedule C on an income tax return? That's where you find out a lot of these things.
I did, Your Honor. I brought it up.
Schedule C, that's a big
Your
thing.
Honor. And so I think the trial court had a dilemma, and that's why it came up with its order in the child support provision. He admits at trial, the appellant, that he makes between $35,000 to $75,000. He makes 10% of his gross income by his business. The court took into that consideration, as well as all the other considerations, evidence that was introduced, that his income was imputed much higher. However, the court decided to give him a boon by only assessing a $90,000, and the appellant is disagreeable about that. In fact, the court issued a smaller amount of child support at $75,000. Now, if he wants to go back to court and have the court do and that's what they're asking for. They're asking for something that has never been done. They're asking that the trial court do a process of elimination and a process of finding whereby after that the affidavit is impeached, that the gross income is not accurate, and the court takes into consideration its experience and all the evidence before it, it must still do a accountant bean counter calculation. And that's not what the law was at that time. It may be the law today that we have with our new child support guidelines, but that was not the guidelines then. And I believe the court had sufficient evidence to make its decision. In any regard, there's been no evidence cited by the appellant that that was an abuse, that he has been held to an onerous standard. In fact, if the court looks at the transcripts, look at the evidence that was introduced, the court was quite fair, was quite judicial.
What do you say about the 25% award of child support?
I knew you were going to ask me that. I knew you were going to ask me that.
Well, I know you're prepared.
I had a dream last night you were going to ask me that. Far be it from me to try to understand the Superior Court and the lower court, or a judge's
But there is no reason present in the order which...
I think that he tried to do a Solomon maneuver. I think that was where he was trying to fashion a amount of child support based upon the shared physical custodial agreement of the parties and placed into reality based upon the disparity of the two incomes of the parties. My client cleans houses. My client has been a housewife for the 12 to 13 years of the marriage. They say she should go back to work. What? She works at a Kentucky Fried Chicken as a clerk. They want her to go back to realty. Well, ladies and gentlemen, if you've been reading the paper, realty is not a great business anymore. Plus, she has a 10th grade Romanian education. She has limited transferable skills. She has limited work experience. There's the necessity to extensive training to provide viable earning capacity. Plus, there's the complication of the present child rearing. She has a 4-year-old at home. But they expect her to work 40 hours, plus raise a 4-year-old, plus have the 2 other boys come and stay with her 50% of the month. I thought the court did an admirable job when it came to the fashioning of this order.
But there is no reason stated in the order as to the deviation from...
Well, I believe they do, Your Honor. They cite that there are special conditions, special circumstances. They made written findings in the order, the court did, that they is deviating from the percentage because of the special circumstances, which is part of the code, which is shared physical custody and disparity of income of the parties. Plus, we could have had another provision, which is the high income of the father. But the court didn't put that in there. I guess it could have, but it really didn't need to. It's a fair order. It's justice. And that's what the purpose of domestic law is, to do justice. And the Superior Court, the lower court, did justice. And I asked that if you sent anything down, you send it back down to the lower court to fix that commencement date, which is what we wanted all along. And that to leave the order as is when it comes to the amount of child support, because that's the crux of the whole appeal. They don't like the amount. They want another day in court. They want another bite of the apple. And they're arguing evidence that this court really doesn't have the prerogative to deal with. The evidence is for the trier of fact, and the evidence that was before the trier of fact substantiates its order. And I ask that you deny their appeal, but remand it back to fix that clerical order. And thank you again for my opportunity to appear before this honorable court.
All right, thank you. I think you have a few seconds left.
Very little time, but let me point out that there's nothing in the record that shows that appellant agreed that Mrs. Banshee should have alimony or should receive child support, although we do contend that all three boys should be properly supported. This order is inherently unfair to the two children who are in Mr. Banshee's custody who do not receive any support from their mother or any set-off from their mother. There was sufficient precedent under Eldridge for the court to make the appropriate findings of fact. We note that special circumstances are mentioned. Although they are mentioned, they do not support the order. Just as in Eubanks, where the court said that an extended visitation did not favor increased support, in this case, shared custody does not favor increased support. We ask this court order the mother to support the two boys.
Thank you. Court is adjourned.